Welcome to Paradox. I got the paperwork, y'all. I got the paperwork. We're going to get right into it. What I'm holding here is, this is my First Amendment petition for compensation for wrongful conviction under ORS 30.657. And it says, jury trial requested, not subject to mandatory arbitration. Put on these reading glasses. Make this a little bit easier. All right, here we go. See a little better. All right. Jury trial request is not subject to mandatory arbitration. Prayer amount. Ooh. $1,578,375. Filing fee paid prior. And so it says, petitioner alleges. On February 10, 1999, petitioner Joe McCool, hereafter, McCool, was indicted on 14 counts, to wit: attempted murder with a firearm, count 1 through 5, assault in the first degree with a firearm, count 6 through 10, and unlawful use of a firearm, count 11 through 14. McCool proceeded to a jury trial. On October 4th, 2000, the jury returned a verdict of guilty on counts 1, 2, 6, 7, 8, 9, 10, and guilty on lesser included offenses of 3, 4, and 5. All verdicts were non-unanimous. The Honorable Kimberly Franco signed the judgment May 18, 2001, April 16, 2001. The court sentenced McCool to 300 months of incarceration of those unconstitutional verdicts. McCool denied committing the crimes on which he was charged. He maintains his innocence throughout all proceedings, including the criminal prosecution and trial, appellate proceedings, and state and federal post-judgment proceedings in which he sought relief for the judgment. On April 2, 2021, McCool, through counsel, filed an amended petition for post-conviction relief in McCool v. Kelly, case number 20 CV 2506. McCool sought relief against the non-unanimous verdicts under which he had been sentenced. Relief was granted on the United States Supreme Court case Ramos v. Louisiana, 590 U.S. 83, 14 S. CT 1390 2000, and the Oregon Supreme Court case Watkins v. Atkins, 370 OR 604 523 P3D 86 in 2022. McCool's non-unanimous verdicts was vacated, and he was returned to Multnomah County Circuit Court for reinstatement of criminal case. On or about October 17, 2024, the trial court entered a judgment dismissing all charges brought by indictment. McCool complied with his duties to provide notice to the state of his intentions to file a petition for wrongful incarceration by providing a written notice to the Office of the Director of Administrative Services, and B, filing a petition to commence his actions. Both occurred within a 180-day notice period. As a direct result of the non-unanimous verdict, McCool was wrongfully convicted from April 14, 2000 to March 6, 2023, a period of 274.5 months. 274.5 months is 22 years 22.875 years. So 22.875 years. So that's 22 years, 8 months. It looked like a week and 5 days maybe. But McCool did not commit the crimes on which he was charged. McCool was not an accessory or an accomplice to the crimes on which he was charged. McCool was not involved in any manner of those crimes. He did not commit perjury, fabricate evidence, or by his own conduct cause or bring about the conviction for the crimes of which he was charged. McCool is entitled to all relief authorized by ORS 30657, including $65,000 per each year and a pro rata portion thereof of incarceration adjusted pursuant to statutory authority, and $25,000 per year and pro rata portion thereof of post-prison supervision adjusted pursuant to statutory authority. For all these claims filed in January of 2025, McCool is entitled to $69,000 per year and a portion thereof, of which incarceration of $26,500 for each year and portion thereof of post-prison supervision. Petitioner is entitled to bring an additional claim for attorney fees and costs pursuant to RS 30657, subsection 7, subsection 8. Jury trial demanded. Petitioner McCool demands a jury trial. Hereforth, petitioner pray for judgment as followed against defendant State of Oregon. For judgment in favor of petition in the amount of $1,578,375 for 274.5 months of unlawful incarceration. Reasonable attorney fees and costs pursuant to ORS 657, subsection 7, subsection 8. Reimbursement for all restitution, assessment fees, court costs, and all other sums paid by petitioners required by a pretrial order, incarceration, and judgment and sentence in a proceedings that gave rise to a conviction and reversal of conviction pursuant to RS 30.657, subsection 7, subsection B. And it was dated on, I believe, Monday, the 8th. And so there you have it, y'all. That's the petition. The amended petition. And we got the paperwork. And so we're going to go through, like, we're going to reverse engineer this thing. Like, you see the lawsuit, but how did it happen? How did we get here? And so part of it is Atkins versus Watkins. And so we're going to walk you through that. We're just going to get right into it. It looked like Justice Baldwin had a concurring opinion. And this, we're just going to read straight out the record because this is important. This is a lot of institutional racism, systemic racism is in these documents, man. We got the paperwork and y'all need to see. It's very important. This issue here right here is the issue. You got it in black and white. Justices saying it. Supreme Court justices from the highest to the state articulate the systemic and institutional racism. So let's just get into Baldwin's concurring opinion. And this is Watkins versus Atkins. This is the Oregon Supreme Court that got me, that I won on. And I got won my appeal. So check it out. Justice Baldwin concurring said, I agree with the majority's view that the petitioners is entitled to post-conviction relief for the denial of his Sixth Amendment right to conviction by a non-unanimous jury. In reaching that decision, I recognize that it is not necessary for the majority to fully discuss. Let me switch my glasses up, y'all, so I can see. Right, boom. Majority to fully discuss the pernicious discriminatory purpose and effect of Oregon's constitutional provision that permitted non-unanimous verdicts. I write separately because I think that a commitment to the rule of law requires us as Oregonians to better understand the troubled aspects of our history, lest we repeat it and yet again cause great injury to our civil health by the adoption of an exclusionary law. And so it starts off with Ramos. So I begin with an examination of the extent to which the Supreme Court in Ramos v. Louisiana says begin with an examination of the extent to which the Supreme Court in Louisiana versus Ramos, SC 1390, 206 LED 2D 583-2000. That's the site number. You got to bear with me on the site numbers, but I'm just trying to, be thorough about it. So you guys, if you want to look into it, you can look into it and just listen to the site numbers. And if you Google Louisiana versus Ramos or Ramos versus Louisiana, it's going to pop up. So it says, expressly recognize the discriminatory purpose and effect of Louisiana and Oregon's non-unanimous verdicts law. And this is crazy because right now, see murder, I'm free. And, I would have been out of jail by now anyway, but I got out early because of this. But a man like C. Murder, even with all all his fame, rich brothers, he still can't get free. And he's in jail unconstitutionally right now for this same law because they didn't make it retroactive, and hopefully they do. And see, that's the cause in Louisiana. If you want them, I think it may be 400 people. I'm not sure how many people, but it's a lot of people, a lot of black men in Louisiana that's locked up still right now for non-unanimous verdicts. And they wouldn't let them get out because they didn't make their law retroactive like we did here. And all because of, because one state, us, we're in a blue state, and them in a red state. Our dissenting judge, Justice Kagan, put on the bench by Barack Obama, she gave the dissenting opinion, and it's going to get more into it in here. And so, let me just get into it, y'all. It says, in striking down Louisiana and Oregon's non-unanimous verdict law, the Ramos court announced that a jury must reach a unanimous verdict to convict, and that the Sixth Amendment right to a jury trial is fundamental to American scheme of justice and incorporated against the states under the 14th Amendment. Ramos, U.S. at 140 SC at 13997 or 1397, citing Duncan v. Louisiana. And now I'm gonna just start skipping the sites. I'm gonna just name them and you can look them up. While the discriminatory purpose and effect of the non-unanimous verdict law was not central to the Supreme Court legal analysis, the court considered the discriminatory purpose and effect in reaching its decision. As pertinent here, the court asks an uncomfortable question. Why do Louisiana and Oregon allow non-unanimous verdicts in Ramos? The court then candidly answered that question. Check it out, y'all. It's deep. It's heavy, man. Shout out to Eliza Kaplan, because she the one that got all this stuff going here, man. Thank God for Eliza Kaplan. She's a blessing, y'all. She did the Ramos project, and she worked for Lewis and Clark. She's a hero. And so it says, though it's hard to say why these laws persist, their origins are clear. Louisiana first endorsed non-unanimous verdicts for serious crimes at a constitutional convention in 1898. According to one committee chairman, the avowed purpose of that conviction was to establish the supremacy of the white race, and the resulting document, including many of the trappings of the Jim Crow era, a poll tax, a combined literacy and property ownership test, and a grandfather clause that in practice exempt white residents from the most onerous of these requirements. Adopted in 1930s, Oregon's rule permitting non-unanimous verdicts can be similarly traced to the rise of the Ku Klux Klan in efforts to dilute the influence of racial, ethnic, and religious minorities on Oregon's juries. In fact, no one before us contests any of this. Courts in both Louisiana and Oregon have frankly acknowledged that race was a motivating factor in the adoption of their states' respective non-unanimity rules. Non-unanimity rules. It says, concurring opinions in Ramos also acknowledge that those pernicious laws have successfully accomplished that discriminatory purpose. Justice Kavanaugh emphasized that those laws have allowed convictions of some who would not be convicted under the proper constitutional rule, and have tolerated and reinforced a practice that is thoroughly racist in its origins and have continuing racial discriminatory effects. And he also said that in Ramos. And now this is Justice Kavanaugh, y'all. This is a Donald Trump appointed justice. And this is his, he's concurring in Ramos versus Louisiana. And so it says, similarly, Justice Sotomayor expressed her views that the racially biased origins of the Louisiana and Oregon law uniquely matters here. This is so in part because Louisiana and Oregon have not truly grappled with the law, sordid history, and reenacting them. The sordid history was only recently addressed by both Louisiana and Oregon, which I will briefly discuss before going into more details on Oregon history. Before the late 1800s, Louisiana required a unanimous verdict for felony convictions. Right. It said that changed, however, after ratification of the 14th Amendment and passage of the Civil Rights Act of 1875, which prompted the United States Supreme Court to prohibit states from barring black jurors from jury service entirely. And this case is Stroder versus West Virginia, and it spells Strauder versus West Virginia, 100 U.S. 303, 25 LED 664, and this is in 1879. And it says aggregated by Taylor v. Louisiana. And then it says C. Reddick. And so it says, following Stroder's, Louisiana convened a constitutional convention in 1898. Ramos, U.S. at 14 SC at 1394, Reddick, 2021 KP 01893 at page 7. The purpose of that convention was to establish the supremacy of the white race, according to one of the delegates. It says, and that's in Ramos. Louisiana sought to avoid an investigation by the United States Senate into whether Louisiana was systematically excluding black jurors from juries. And its solution was to undermine black jury participation on juries in another way, by permitting the use of non-unanimous verdicts for serious crimes. Similarly to Louisiana, Oregon required a similarly to Louisiana, Oregon required a unanimous jury verdict from 1864 until 1934. See State v. Lawson, 252 OR 624, 626, 450 P2D 754 1969. Oregon amended its constitution to allow for non-unanimous jury verdicts in all but first-degree murder cases in 1934. Eliza Kaplan, there she go. Eliza Kaplan, non-unanimous jury law in Oregon, Oregon Encyclopedia, and a bunch of sites. The Oregon Criminal Trial Without Jury Amendment. It says, was on May 18, 1934, and this is Measure 2. Was on May 18, 1934. Ballot as a legislative referred constitutional amendment. Official voters pamphlet special election, May 18, 1934. Got a 6. The measure was approved by voters. It thereafter amended Oregon's Article 1, Section 11 of the Oregon Constitution, as well as former ORS 136, period 610, 1953, renumbered as ORS 136, period 450, 1973, which governs unanimity requirements for juries in criminal cases. The Oregon Supreme Court was faced with the question of whether to end the practice of using non-unanimous guilty verdicts prior to United States Supreme Court decision in Ramos. In 1969, the Oregon Supreme Court had shown that the Oregon procedure was suited to Oregon conditions and that the Oregon system has been as just as the system in jurisdictions requiring a unanimous verdict. State versus Gann. And then, so in 1970, this court was again faced with the question of whether to end the state's non-unanimous verdict practice when it denied review of a claim that conviction for a crime by a less than unanimous jury violated claimant's right to a trial by jury under the Sixth Amendment. It said, the United States Supreme Court granted cert of the claim and affirmed, upholding Louisiana and Oregon's ability to continue using non-unanimous jury verdicts. And that's Apodaca v. Oregon, 406 U.S. 404, 406, 92 SCT 1628, 32 LED 2D 184, 1972, overruled by Ramos. And so that's Apodaca. That's the case that was in Oregon that they that Justice Powell abused his power about, man. He abused his power. He did something that he knew was unconstitutional, and he did it just because he could. And see, that's the thing. It's all about the gatekeepers, man. You know, and you got to put gatekeepers in there that's going to protect the interests of the people and not some political agenda or, just because they can, they got the power to do it. And back then, really, it was unchecked, no consequences, and they still haven't. They should get sued. You see what I'm saying? That shit, nobody should be above the law. There got to be some accountability. See what I'm saying? We definitely, I'm going to talk to my attorney. He don't know it yet. But after this case get done, I'm gonna be like, look, man, let's sue the United States government, man, because Justice Powell abused his power, and it's on the record. And his actions had consequences on a lot of people's life, man. And nobody should be above the law, man. The Constitution got to stand. That's real, so. So yeah, Louisiana and Oregon were finally forced to face the sordid history of their respective laws in 2020. After the United States Supreme Court decided Ramos, the practice of using non-unanimous jury verdicts was ended in both states. There could be no question either that the Sixth Amendment unanimity requirement applies to state and federal criminal trials equal. And it's, case law, Eulery. Ramos leave no doubt that Oregon's acceptance of non-unanimous guilty verdicts must change. And so the Supreme Court later determines that its decision would not apply retroactively and instead left it to the states to determine whether to apply Ramos retroactively. See, this is Edward versus Vinoy. And when we was in prison, we was all sitting on this case like, man, they gotta make it retroactive. They gotta make it retroactive. This is the only time that standard for retroactivity it fit this scenario. And so when they came back in with Vinoy with the ruling, we was kind of sick. But I knew, me myself, I was like, they left it up to the states. Oh man! And then I seen Justice Kagan's dissent. Let me get to it, y'all. The Supreme Court later determined that its decision would not apply retroactively, instead left it to the states to determine of whether to apply Ramos retroactively, and that's Edward v. Vinoy. The case site is 141 SCT 1547, and then comma 1559 and 6, and then comma 209 LED second, 2D 651, and that's in 2021. And so states remain free if they choose to retroactively apply the jury unanimity rule as a matter of law in state post-conviction proceedings. See, the Supreme Court had it both ways. I mean, they like, look, this is what happened. It's up to y'all. Y'all handle y'all business. And so Justice Kagan noted that those majority and concurring opinion relied on a strong claim about racial injustice. Edwards, and that's in Edwards, Kagan's dissenting. And so the Ramos majority had explained that the non-unanimous jury rule were meant to dilute the influence on juries of racial, ethnic, and religious minorities and to ensure that African American jurors service would be meaningless. And that's in Edwards, Kagan's dissent, quoting Ramos. Justice Kagan noted further that Justice Kavanaugh's concurring opinion in Ramos linked that history to current practice. In light of their racist origins, it is no surprise that the non-unanimous jury can make a difference, that then and now they can negate the vote of black jurors, especially in cases with black defendants. And that comes from Edwards. That's Kagan's dissent. It says most alterations in original, quoting Ramos, and it gives the site 140 SC at 1417 through 18, and that's Kavanaugh, and he's concurring in part. But Justice Kagan stated that assertion preclude the majority's result in Edwards. If the old rule functioned as an engine of discrimination against black defendants, its replacement must implicate the fundamental fairness and accuracy of the criminal proceeding. The unanimity rule helps prevent racial prejudice from resulting in wrongful convictions. The rule should therefore apply not forward but back to all convictions rendered absent its protection. And that's from Edwards. That's Justice Kagan saying it should apply retroactive. See? And that's in Edwards, Kagan's dissent. It says, the dissenters in Edwards concluded that a decision like Ramos come with a promise, or at any rate should. If the right to a unanimous jury is so fundamental, if a verdict rendered by a divided jury is no verdict at all, then the petitioner should not spend his life behind bars over two jurors' opposition. And that's in Edwards, 141 SC at 1584, and that's Kagan's dissent. It says, despite the dissent's sound reasoning, the majority decided to leave the question of retroactivity to the states. See? And that's just, it's messed up because it just depended on what state you in. I'm in a blue state with a blue Supreme Court, so they made it retroactive because Justice Kagan's dissent. But then if you in Louisiana and you in a red state and you got a red Supreme Court justice or bench in Louisiana and a red legislature in Louisiana, it's all bad. So it says, following Ramos and Edwards, in 2022, the Oregon legislature introduced Senate Bill 1511. That bill sought to create a process by which a person convicted or found guilty as a result of a non-unanimous jury verdict could file a petition for post-conviction relief within 1 year of the act effective date. In other words, the bill would have applied the Ramos decision retroactively. The bill died in committee in early 2022. When it happened, man, we were sick, but we were still hoping, like, man, the Supreme Court gonna come through. And so, man, I'm reliving it with y'all right now, man. It was woo, it was just, man. So, he said around the same time that SB 1511 was introduced, the court was presented with the task of determining whether to apply Ramos retroactively following the appeal, in this case from a trial court's rejection of a post-conviction petitioner's challenge to its conviction obtained through non-unanimous verdict. It says Louisiana's reaction post-Ramos recently came to a head when its state Supreme Court decided not to apply the Ramos jury unanimity rule retroactively. See what I'm saying? Just because they're in a red state, man, it's just not cool. You know, where's the equal protection in that? You see what I mean? But we do got we got the 10th Amendment, so states' rights. And so that's the quagmire though, man. That's what's messed up about it all, you know? And so yeah, no retroactivity yet in Louisiana. It ain't like it can't happen, but that's what people in Louisiana, man, need to be pressing on. Like, look, the Constitution gotta survive, man, and institutional racism was involved, systemic racism was involved. You guys need to let them black men out of jail that's in jail unconstitutional, including C murder, because the Constitution got to survive if we expect our country to survive. If we want to have a country, we got to have a Constitution. And that Constitution should apply equally to everybody and protect everybody. And everybody should get the same justice under law. And so, you know, people in Louisiana, man, y'all should stand up, you know, and protest and march and, you know what I mean? Stand up for them brothers, man. What y'all need to do is put in people in their legislative, like in Congress, that's going to, you know, make sure, like, look, black people, we ain't voting for this man unless he try to get them black people out of jail. You see what I'm saying? They got to press the legislators. They got to put pressure on them to bring a bill forward that make non-unanimous retroactive. And they got presidents. I mean, they did it here in Oregon. It can be done, you know. And I mean, I'm assuming, like, I don't know the facts behind this, so just, you know, but I'm assuming the people that did get on non-unanimous, they ain't going back to jail. You know what I mean? They didn't did so much time. They be cool. So, man, let them people out. So y'all need to, man, y'all need to become congressmen and senators so y'all can help them people get out. You know, the people of Louisiana that are, you know, boycott. You know what I mean? I'm saying, like, look, y'all need to let them people out the penitentiary, man. They sitting up there unconstitutional. The state legislator do the right thing, man. There was institutional racism or systemic racism on that situation. It's documented. Do the right thing. Let them men out of jail. And we ain't voting, black people, we ain't voting for you unless you put that bill to the floor. And we ain't voting for you unless that get changed, man. For real. And y'all need to put pressure on them people. You know, get the men out of prison, man. That ain't what's up right there, man. I mean, it's in black and white. You know, that's the rally, man. That's the cause. That's the mission. And so it says, although Louisiana courts went through its state ignoble history surrounding its now outdated non-unanimous verdict rule, it nonetheless determined that the history was not enough for it to apply Ramos retroactively. Instead, opting to leave that decision in the hands of the state legislature. See, they leaving it in the hands of the state legislature, and so they just pass it back and forth. You take the potato, you take the potato. So when some, Oregon and Louisiana created non-unanimous verdict laws that deprived many defendants, particularly defendants of color, of their Sixth Amendment rights for decades. Neither state fully addressed the discriminatory purpose or effect of their laws until the United States Supreme Court decided Ramos, and the state was ultimately forced to examine their law's history.